Hi, Lourdes, and welcome to our show.
Well, thank you for inviting me onto your show. I really think this is an important issue to discuss, so I appreciate you giving me the opportunity to talk to you about this issue on Siesta Key.
Yes, we appreciate for taking the time. I know that you are busy with many other things, and for the interests of our communities around in this South County, we have been watching your determination to do what is right for your community, and I commend you for that. So here it is, the time to tell us the story in your own words instead for us, to imply what has happened. So please.
Well, I'm glad you pointed that out, because the win we had for Siesta Key is actually something that can impact the entire county. In a nutshell, it's basically the county violated the comprehensive plan, and we went to the state, and then I'll go into detail in a minute. So I went to the state to tell them, and they agreed. The county has to follow the comprehensive plan. So that message, the message that a municipality or a county government must follow the comprehensive plan, it resonates with all of Sarasota County, or even outside of Sarasota County. But I'll tell you what happened. In October 2021, the developers came before the county commission to do two things. One of them was to change the zoning code to eliminate the maximum density hotels had, which at that point was 26 units per acre for hotel rooms without a kitchen. If it had a kitchen, it was 13 units per acre. And to eliminate the definition of transient accommodations, which is hotels, of being a residential use. So once they accomplished that change to the zoning code, saying that it's no longer a residential use and it's eliminating the maximum density, then they went on to approve hotels on Siesta Key. Now, the first hotel they approved was 170 unit on less than an acre. So we went from 26 units per acre maximum to 170 units per acre. And they also included a rooftop bar, a restaurant, shops, and a parking garage, all in an acre. So you can, and this is 8 stories. So you can imagine how massive that is for this small parcel in the village on Siesta Key. So I needed to do two things. As a citizen, I can challenge the zoning code change, because the zoning code has to comply to the local growth laws known as the comprehensive plan, which is dictated by the state. The state says you have to have a plan for growth. That's called the comprehensive plan. And then the zoning code must match the comprehensive plan. So when the county changed the zoning code, they didn't change the comprehensive plan, which says that on 4 barrier islands, the maximum density and intensity must be as it was in March 1989. So here they made a change to the density, maximum density for hotels today in 2021, but the comprehensive plan said you can't increase it more than what it was in March 1989. So I went to the state with that complaint saying, okay, here they changed the zoning code, eliminating the maximum density for hotels. And now that does not match the comprehensive plan that says you have to have a maximum density for hotels. Well, it says you have to have a maximum density. And then as of March 1989. Oh, sure.
Just for the sake of people who are going to watch this video, it's important because I was not familiar with comprehensive plan when I came to Florida. There is a state law that each county, each municipality has to file. It's a document second in order after the Constitution, which is the charter of the county or the municipality. The comprehensive plan is mandated. It has to be approved changes to it by the state. So it's not like it can be changed at a meeting of the local government body. It has to be consistent over time and has certain way in what it's happening. So what you describe is changing zoning, which is a subset, is not. So the high level document, which is the guiding, it's the comprehensive plan. And then you depicted that they voted in 2021 something at the lower level, which is inconsistent with the, let's say, constitution of the land development, correct?
Correct. They did that, and that's where the situation came to a head. We needed to go. I needed to go to the state and say, okay, the county passed this zoning code change. Now it's not consistent to the, like you said, the master document, which is the comprehensive plan. And there was almost 2 years of going back and forth with the developers and the county, who were claiming, well, in March 1989, there was no density on the barrier islands. It was unlimited. And we were saying, no, here's the documents from 1989 that says there was a maximum density. And so it was a battle back and forth. And eventually, as you know, 2 weeks ago, the state came back and said there was a maximum density, and there was a lot of documents to prove that back in the 70s and 80s, Sarasota was concerned about the growth of the county. They were concerned about where we placed things. And they were concerned in particular with the barrier islands because everybody seemed to be building there. And that's why they put in rules such as saying, okay, barrier islands is a sensitive area subject to hurricane. We have to evacuate in hurricane class 1. And we only have 2 bridges that goes off Siesta Key and a 2-lane road that connects those 2 bridges. So we have to be concerned how many units we put out there, how many tourists we put out there, because we would have to evacuate them. This is what we were hearing in the 70s and 80s. We have documentation about how concerned they were. And they even did a study in 1979 about how Siesta Key is overly developed and can't handle what it had in 1979. Much less what we saw since then. So it was obvious to the judge that we had maximum densities on Siesta Key, and this change that says, okay, there is no density, you can build whatever you want, just does not comply with the comprehensive plan. And so I was grateful that she understood because it's complex, and I was concerned that, you know, it was muddied by the developers, but I'm glad she agreed with us.
So that was, go ahead.
Lourdes, what I wanted to ask you is, and you mentioned before the land code, and we know every jurisdiction has their own land code. In Northport, it's called the ULDC. And how is it that they were able to, that they violated the comprehensive plan? And did they also violate the land code? Because they have to match, like you said.
Well, what they did was they changed the land code. So that's what they did. They changed the land code saying there's no density for hotels. The problem is it didn't match the comprehensive plan.
So
and
again,
so
it's like a law is not consistent with the Constitution and is declared unconstitutional. The same way, if the ULDC, Uniform Development Code, is not consistent with the comprehensive plan, then the comprehensive plan is the authority in the matter.
Right. And in this case, what they did was the change that was the ordinance that made the change was inconsistent. So the zoning code will continue as it is, but this change they made is not valid because it's not, it does not work with the comprehensive plan. So that was a big, huge win for Siesta Key because that affects all of Siesta Key. I'm also suing the county on the fact that they approved a hotel at 170 units when it should have been 26. That lawsuit has to go to circuit court, not the state. So for the state, you have to, when you file a claim, it's about the zoning ordinance change. But in circuit court, you've challenged any approvals that the county did based on that change. And that's still in the courts. We have a hearing this Thursday to talk about how we're going forward with that case. But at least I would say phase 1, which is the throwing out the zoning ordinance change that was inconsistent is now that done. And now we just have to challenge the approved hotels.
So Lourdes, you and I are longtime residents of Sarasota County. I'm here over 20 years and I come from the East Coast, Miami, et cetera. You've been here longer than me. Tell us how this impacts the 2050 plan, or is that even gone in the county?
Well, it doesn't impact the 2050 plan specifically. I mean, it does say, you know, if you're going to have something in the code for 2050, which is the land development regulations for East County, you have to follow the comprehensive plan. You know, so the overall message, the county must follow the comprehensive plan. It is going to impact 2050, even though they don't talk about the villages or anything in specific to that plan. So
Yeah,
I think it's a strong message, because the one message I've been getting from a lot of neighborhoods is that the county has approved development and changes for the past few years, and they were concerned about challenging it because, you know, you put your self on the line when you do that. And so seeing that we actually won a case is as my attorney calls it, monumental. That, you know, we actually proved that the county has violated the comp plan, and I'm sure there's been other instances. It just hasn't been taken to the state.
well, that's why I said that I commend you for taking this yourself to prove that the law pertains to every entity of the state, or, you know, it doesn't matter. The law is there. And I think you set a precedence that can be leveraged by anybody in Florida. It's not only for the South County. So what you want the right of the people to challenge what is unconstitutional, when I refer as constitution of plans of development, comprehensive plan, because all the municipalities, all the land in Florida has to abide by these comprehensive plans. So what you want is a message saying, well, all the local governments have to abide by it, by the comprehensive plan. You cannot go and make changes through a resolution which is inconsistent with the comprehensive plan. So that's the huge win for the people of Florida. So thank you for doing that.
I appreciate that. There have been a lot of court cases that have been saying it in the past. I think we just haven't seen anything recent that said that the county, you know, municipalities, all government must follow the comprehensive plan.
Yeah, and I understand. Since I came here 7 years ago, I haven't heard of anything. So you are, during my Floridian time, you are unique. So.
Can I ask you, what is the relief that you're seeking from the court? Is it just to force the county to abide by their comprehensive plan, or is there something more?
Well, when it comes to the state courts, it's just that. It's just forcing the county. First of all, it would invalidate the code change because that is inconsistent. The county cannot use that zoning ordinance to approve hotels because it's now invalid. But also to tell the county clearly, you must follow the comprehensive plan. So those are the only two reliefs you can get in state court, is just to get that message across.
But then, as you said, you are on the circuit court where you will have using that decision to challenge the density and, have further wins with respect to your local community.
Well, that's true, because they did approve 3 hotels on Siesta Key. I'm challenging just one of those 3 hotels. But, you know, we have to go and challenge something that doesn't belong. And that's not a strong message. We have to tell everyone, you know, if you really want something and if it is good for the community, then do it the right way. Don't circumvent the system by putting in a change that, you know, doesn't comply with the comp plan, and then just keep approving hotels without really thoroughly looking for it. The sad part was I went before the Planning Commission in Sarasota County and the County Commission pointing out that they're violating the code. And I don't understand how it's still passed. You know, if some people go before a county commission or government and said, oh, you're doing something wrong without facts, I could see how a county commission can possibly approve something without knowing those facts. But what I did was I went before the planning commission and the county commissioners with actual facts, showing them this is what you're doing wrong. This is what it says in the comprehensive plan. This is what we have to follow. And the actual policies they were violating, and still they approved it. And so it's wrong for the county to approve something, even though they could see that there's something clearly wrong with this picture. And I think only the late Nancy Dieterts questioned it, but no one else did.
I do remember because I attended that meeting, and
Oh, I would.
Did public comment.
yeah.
Right,
we
that's
did a
right.
public comment.
I appreciated the support. We had you, we had people from all over the county, and then
I
we
know.
had at least a couple of hundred people from Siesta Key, and we were not listened to.
And that's surprising. I know over here we had, and Victor and I talked about it about a year and a half or 2 years ago. We had the same thing happen where the city was violating the comprehensive plan in multiple ways, and they wrote the comprehensive plan. They totally rewrote it when they got in office in 2016. And it was a little area called Talon Bay. And I know Victor was on the utilities board at that time, and he saw this coming almost a year before. The Talon Bay people challenged the commission, and by the time all of the speakers went up to PZAB, the Planning and Zoning Board, and the Planning and Zoning Board told the city, no, you can't make these, you can't make these, they were putting in a public facility, a campus. The Planning and Zoning Board said, no, you can't do it. They were going to do it anyway. So everybody went en masse to this meeting for the commission, and to the end, there's only one commissioner that continued to hold on to the ruling or the decision that she was going to make this happen. And she gave like a 20-minute speech about, well, let me rewrite. She was actually rewriting it on the dais. And so finally they just had a vote and they said, no, I guess we can't do it. But the Talon Bay people had to hire an attorney, and they had to pay their own attorney. And I always wondered, why didn't the city have to pay back, or why wasn't there any sanctions against the city for clearly violating their comprehensive plan? And I wondered the same thing with you. Why are you having to hire an attorney, pay for the attorney, and it's the county not doing the job?
It's a shame that the citizens like myself has to do that. And that's why I think a lot of citizens just give up after the county makes a decision, or municipalities are like, oh, I'm not going to find an attorney and spend the money. But I was so clear to me, that was such a clear violation. And I know the code so well that I had to go all the way. And I'm grateful to, there are citizens out there who donated towards the cause, and that really helped with some of the expenses. And as individuals, because a lot of individuals did, no organizations helped out, but individuals, people did. And that was helpful, because I would get words of encouragement when I'm walking down the street, go, get them. And I really appreciate that support. But it's a shame still that we have to do it, And
what is the website in case somebody would like to help?
Well, great. Thank you. It's siestakeycommunity.com. Altogether, siestakeycommunity.com. And that's where I have a donation button to help out. Any little donation.
Now people can get on your email list and have continuous updates sent to them.
Yes, especially since we're still going forward with the circuit court case. And
Yes.
and that's dragging on a little bit. Of course, we submitted the decision from the state to circuit court as supplemental information, so they can have that when they make a decision, because I do have a motion for summary judgment before the judge, but there has been a judge switch, and because one recused himself, and so everything's a little bit in flux there. But hopefully we have a trial date in October, so if we don't get the motion for summary judgment, we can go to trial, and that'll hopefully end that.
It's a good plan, but again, I will reemphasize, we probably should put a slide in the video with the website address.
Do you remember the date of that hearing in the county? I'd like to pull up some of those public comments, yours and Victor's, and there are a couple of other people that really impressed me because I was sitting next to Victor. And I'd like to add some of those public comments, if it's okay with you, to your interview here, so that people can see it was clear that the county was told, and I think an attorney went up and discussed this, and they went ahead anyway. And I think it's important for people to see this is how a government, and I don't want to call them corrupt, but I certainly want to say this is a government that doesn't listen to the people when it was clear that the people were correct. So do you mind if I add some of those, or Victor and I add some of those public comments?
Oh, not a problem. It's October 27, 2021 was the Board of County Commission meeting. The Planning Commission meeting was August 19th, but I think that's a great idea because you could see at that point where there were attorneys, there was myself, there was Victor. So many people spoke and a lot of them reiterated you have to follow the law, and yeah, the county commissioners ignored it.
Okay, we'll add some of those so that people can see what you did. And you know, I'll have to say, I give you so much credit. I've known you for years and you've always fought the good fight and they've always fought the bad fight. And I'm really, really very happy. And I congratulate you for winning at the, what is it, the administrative level.
Thank you. Yeah, it was the Florida Division of Administrative Hearings is where we challenge you. First, go when you have a comprehensive plan challenge, you go to the Department of Economic Opportunity. They're the ones who say yes or no to comprehensive plan amendments. And in that case, they, of course, they said that the zoning ordinance complied to the comp plan. So then you go to and that's an informal comment by the DEO, but then you go to a judge in front of the Division of Administrative Hearing, also known as DOA. We call it DOA for short. And then you do, that's the real actual case to challenge anything with involving the comprehensive plan.
Okay, perfect, perfect. Okay, is there anything else that anybody wants to add?
You mentioned that the circuit court, is it a date when we should look out for, or you don't have a date yet?
Well, the next hearing is this Thursday, and that's just to talk about case management.
Thursday, you mentioned.
And that's just talking about what the next steps are under this new judge, Judge Hunter Carroll. But the trial date is scheduled for October. I think starts October 9th, and they give you a window of about 3 weeks, sometime in that time frame. But I still don't know where our motion for summary judgment of our case is, because we submitted that to the previous judge back in January, and we have not heard back. So it's kind of open-ended, but right now our target is October of this year.
Okay, thank you, because I like probably to attend that one. It would be very interesting.
I'll keep you informed.
Thank you.
One more time, your website, and I'm actually going to put the copy that I received of your website and attach it to this so that anybody can have it right in front of them. But if you can tell us one more time the address of your website.
Well, thank you. It's siestakeycommunity.com. And I put as much information on there as possible, including the link to the decision. So that hopefully people want to be interested in it. They might want to read it. They're more than welcome.
Wonderful.
Thank you very much for your time and valuable information. We are looking forward to have another update in the future after you have the next step completed. Wishing you good luck. We appreciate everything you have done in the years. You have been very active, and you have shown that you are a true leader in this county, and not always the right people get in place, but thank you for all your commitment to the community.
Yes, thank you.
Well, thank you. Thank you both for giving me this time, and I look forward to talking to you again.
Thank you.
Bye, Lourdes.
Bye.
We got to restart the clock. Don't get nervous. We have to restart it, Commissioner.
Yeah, don't shortchange me.
Yeah, that's why I said don't get nervous.
Okay.
My name is Lourdes Ramirez, and I'm here as an individual that is negatively impacted by these proposed hotels and also to represent my company, Siesta Key Community, Inc. I've submitted 2 papers, one 32 pages long, another one 8 pages long, and multiple emails that outline our position and to provide information, including my extensive knowledge of Siesta Key zoning issues. I'm not here to convince you, but rather to remind you that the number one role of government is public safety. For the past few decades, county commissioners has passed laws to protect human life. And here's one of the goals from the 1989 comp plan.
There you go.
They knew that with one 2-lane road and 2 bridges that seasonal, tourist, and full-time populations of the Barrier Islands are in harm's way. Density and intensity have been limited on Siesta and the other Barrier Islands for decades for that reason. And the role of the County Commission is also follow the law, which is in this case is the comprehensive plan. According to state statutes, the county must find all actions in regards to development orders make sure that it follows the comprehensive plan. And this proposed UDC amendment number 32, if implemented, will violate 2 goals, 3 objectives, and at least 6 policy of the comprehensive plan. For one example is policy 2.9.1, that states, with one clear sentence, the intensity and density of future development of the Barrier Islands of Sarasota County Sarasota shall not exceed that allowed by zoning regulations and ordinances existing as of 1989. So you have to ask, what did that 1989 regulation say? The 1989 zoning regulations list transient accommodations as a place of human habitation and as a residential use with a maximum density. The 1989 regulations also had something in the CG district. It listed the maximum density in the CG district for transient accommodations as being 26 units per acre without a kitchen. Redefining transient accommodations to eliminate density today will not change that definition. It will not change that policy. That policy still has to be abided by. The county cannot go back in time to 1989 to redefine density for the Barrier Islands. And it really is bizarre that in your packet 2021-047, that density is allowed for transient accommodations in Nokomis and the BRRPD district, but not for the Barrier Islands. There's also a situation that's also an increase in intensity of use. For now, at that property, you can put in CG like a restaurant. What they're asking for is 3 additional commercial uses. Like for the hotel is a restaurant, a bar, and a public parking spaces. That's an intensity of use for that parcel because we went from 1 use, commercial use, to now 4. And that would violate that same policy 2.9.1. You have to remember the Siesta Key is just sorry, let me skip that because something else came up and I really think it's important that you talk about this. Because when I saw staff's report and they gave you that presentation about what's consistent with the comprehensive plan, they listed quite a few policies and objectives, but they were missing quite a few. In that policy that they listed that the proposed amendment is not going to violate the comprehensive plan, they missed goal number 2, coastal objectives 1.2, 2.9.1, as I just told you about, 2.9.2, coastal policies 1.21, 1.22, 1.25, 1.26, and transportation policy 1.1.4. There's a lot of policies that this proposal violates in the comprehensive plan. So I think it's really important for you to note that, it's not just the ones that they say is consistent with, but it's also inconsistent with all these others. So I urge you to reject UDC 32,
Oh, because it's inconsistent with the comprehensive plan. Thank you.
Thank you, Paul Elms. Victor Dobrin. And if the next five, I see Mike there, but Alexandra Coe, Susan Shetley Gunn, Charlie Bailey, Robert Lincoln, and the last card is Allison Stottlemyre. If you could move forward to help us out, speed things up. Victor, you're all set.
Thank you for taking me back. I am a victim of the traffic, so it's not unique to Siesta. It's all around us.
You're done, sorry. No.
Okay. I'm victimless mentality.
How are you
So-
again?
Thank you. I am living in West Villages, 20327 Real Circle. Good afternoon, and I would like to ask you to consider seriously all the facts and data presented today. I'm an engineer by profession, and I always look at the data as the guiding principle in everything I do. And you have heard lots of data from people who are more astute than myself in this domain, talking about density numbers, comparison with other communities, and the highest I have seen, it was a surprise to me, the highest in Orlando. I thought it would be 100 at least, but you see, there is good guidance there. What I did last night, and I had to commend your planning department, I read a very nice material about the history of the land planning in Sarasota County. An excellent material which grounded me as a Michigander, originally from Transylvania. But I love my adoptive country, and I just returned 2 weeks ago, and I'm blessed to be here. And this forum, it shows me why I tell them there, come and see how the democracy works. It's not perfect, but it does work. So thank you for pointing out also, although the material I learned, you know, the government, local government comprehensive plan and land regulation was voted in the form which exists today, the act in 1985. And we had the examples taking us the policies of the future land use policies, and specifically 2.91, which is so dear to my heart. Maintain government regulation for barrier island land use. Now, I grew in the mountains, grew up in the mountains, but I love the Sarasota County. I think has done some marvelous jobs, and we have nice beaches, which attract not only us, but people from all over the world. Maintaining the safety of the people, you have heard both small businesses and community leaders speaking on behalf of their neighbors, saying it's the wrong thing to do with these amendments, and having special exception is the wrong thing. We all are specials, but I'm not going to ask you to give me a special exception for my house. I have to live by the regulation existing in the books. So I consider there are so many facts today that nobody could say that I can't proceed with a vote today other than maybe delaying, such that the planning department has the time to absorb and review their position. Because when Commissioner Dieter said, why didn't you bring to us this during this year? It was the right time when you actually have revised the Unified Development Code. There was no good answer, I have to say that. But they are very good people, as I said. I admire them for what I learned in one evening reading 1 hour, the document they put together. Thank you. So I also honor the position of the opposition. I think that the lawyers are doing a great job for their clients, but they don't serve the interests of the Sarasota County people. When we started this meeting, we pledged allegiance to the flag and to United States for what? Because we have liberties and justice for all. I'm saying that they have actually opportunity to develop this in a more constructive and respectful manner. So I think everybody should go back to the drawing board, absorb everything they have learned today, as I learned a lot too, and do the right decision. Thank you for your attention, and I don't want to rant you more, but my heart is here. I don't leave, but there is one thing which I am very afraid, and it was mentioned today, the domino effect. And this is going, like when I went through the documents presented by the developer, they listed actually, I don't know, maybe a few dozens of properties which fit that classification. So it's a domino effect. It's just a bomb time, which is going to explode on us, all of us. Thank you.
Thank you. The next is Alexander. With that, we have worked our way through all the cards. I have no further cards. We're now going to move into, Commissioner Moran, we're moving into questions for our staff, but Commissioner Moran, you're on the board. Is that?
No, sir, nothing for questions.
No questions, just a motion. Okay, any questions of staff? I'm seeing none. So with that, Commissioner Moran. No, oh, I'm sorry, we got to do rebuttal.
Mr. Chair, you may also want to know if you have questions for the applicant as well, prior to rebuttal.
Okay, I usually don't, but if you think that's best, that's fine. But start making your way up here. You're only getting 5 minutes, my friend. Okay, just a great, as chairman, I can be for the moment the grandpa, just the four of you, just great competency and great discussion, and thank you. With that, we're on B, motion by Commissioner Moran, seconded by Commissioner Kutzinger for approval. All those in favor signify by saying aye.
Aye.
Is anyone opposed? No. Chair votes aye. The motion passes 3-2 with Commissioners Dietert and Ziegler as noes. With that, we're now going to recess as the Land Development Regulation Commission and reconvene as the Board of County Commissioners. Commissioner Moran, if you're still intending to sequentially do this, we're on A, and please state your motion and include the language in your motion.
Yes, sir, thank you. We're on 2A, which is a public hearing to adopt ordinance number 21-047, approving the Unified Development Code text amendment number 32 to determine transient accommodations are not residential units in commercial zone districts for density calculation.
Is there a second?
I'll second that.
Motion by Commissioner Moran, seconded by Commissioner Kutzinger. If anyone feels they're entitled, motion maker first, second after that, for discussion.
No, sir, nothing further to add.
Commissioner Kutzinger? Okay, there's no one else on the board. We're on item 2A, Madam Clerk. Motion by Commissioner Moran, seconded by Commissioner Kutzinger to approve. All those in favor signify by saying aye.
Aye.
Anyone opposed? No. Chair votes aye. 2A moves forward with a 3-2 yes, with Commissioners Dietert and Commissioner Kutzinger as no. Ziegler. Oh, I'm so sorry. So sorry. Thank you. Long day. We're on. And please don't be insulted, Commissioner Ziegler, that I called you Kutzinger or vice versa. All right. I don't know who I just insulted there. We're on 2C. We need a motion. Commissioner Moran. I just did. Yes. Yeah.
All right, moving on then to 2C, which is again a public hearing to adopt a resolution approving special exception petition number 1824 to allow transient accommodations and an increase in height up to 80 feet in the CG Scott Zone District.
Is there a second?
I'll second.
Okay, we're on 2C. Motion by Moran, seconded by Kutzinger. Discussion?
No, sir.
I see no one on the board. We'll call the question. 2C, Madam Clerk. All those in favor signify by saying aye.
Aye.
Anyone opposed? Chair votes aye. 2C moves forward with a yes, 3-2 yes, with Commissioners Dietert and Ziegler as noes, and there are no open to the public cards, and we're adjourned.